I am discussing the topic of arrest of person under the Code of Criminal Procedure. So far, I have discussed this topic in three video lecture. Now this is the fourth part. So we will see some important provision relating to arrest of person in this fourth part. Let me inform you that the topic which I am giving in this part, discussing in this part, I have also recorded and uploaded my video of this lecture in Marathi language also. So any of you, if you wish to listen my this video lecture on this topic in Marathi language, then please see that particular video. You can also see it in Marathi. You also listen it in Marathi language. So first such section is section 47. Its heading is search of place. So it says that for the purpose of arrest, this section authorizes any such police officer who is having authority to arrest to enter into and search any place like house or building wherein that suspected offender has entered or where that suspected offender has concealed himself. And for the purpose of entering into such house or building, if such a entry cannot freely be obtained, then this section authorizes the police officer to break open any door or window of such house or building. But this section also says if such house or building is occupied by such woman who ought not to appear before the public, then before entering into any such house or building, police officer has to give prior notification that they are entering into such building. So if there are any women in the building, they please go outside. Here this section 47 further says that even though that particular police officer is not having arrest warrant, but situation that immediately arresting such suspected offender is very necessary, and if it is insisted on that police officer to bring first arrest warrant from the court, then by that time it will give opportunity to that suspected offender to escape from that place. So therefore, police has been given authority to enter into any such house or building where such offender is suspected to have entered into or concealed himself. But before doing so, police officer has to notify to such person arrested that he is having authority to arrest you, and therefore he is entering into the house or this building. So this is the section 47. Then next section 48. It says for the purpose of arresting any suspected offender, police officer can pursue such offender at any place throughout India. So police officer can search in such suspected offender throughout India anywhere. Then next section, section 49 is important, and it is also a right of the person arrested. It says that such person to be arrested must not be subjected to any more physical restraint than which is required for preventing his escape. Therefore, any such physical inconvenience like tying of hands must not generally be resorted to. Suppose that person to be arrested submit himself to the police, that means he is ready to come along with the police, then in that case it is not necessary to tie his hand, or it is not necessary to put some physical restraint on him, but such physical restraint is necessary when police officer believes that unless he is restrained, there is a possibility that he may escape. So depending upon situation, police has to take decision, but law says that generally such physical restraint must not be there, and such a physical inconvenience like tying of hands generally not resorted to. Then next section 51, it is a search of person arrested. It is search means, suppose after the arrest, when such person is taken into the police station, then their police officer can search physically that person arrested. Search physically means police officer will search his dress, clothing. Police officer will search his all the pockets of his dress. What are the articles which are kept in the pockets of his dress? Suppose he is carrying any purse or wallet, police officer can check what are the things there in such purse or wallet. Suppose that person is carrying some bag along with him, carry bag. So police officer can check all those things, what is there in such, what is kept in such bag. So police has power to do all such search. But it is said that while making such search of that person arrested, police must not remove from the body of such person arrested necessary wearing apparels or clothes. So police should not remove the clothes from the body of that person arrested. At least minimum required clothes should be there. And when such search is to be made of any female suspected person, that is arrested person is female, then in that case such search must be made by female police officer with strict regard to decency. And then next section 52 says that after making such physical search of that person arrested, if police finds any offensive weapon which is carried on or which is belonging to that person arrested, then police officer has power to take that away from that person, and then police officer has to forward it to the court for the purpose of evidence in the trial. Then section 53 It is relating to medical examination of the body of the person arrested at the request of police. So it says that when any person is arrested on accusation of committing any offence of such nature that there are grounds for believing that an examination of his person, that is body, would afford some evidence as to commission of such offence, then such arrested person can be physically examined by a registered medical practitioner. So what is the purpose of such medical examination? If such person is accused of committing any such offence of such nature that there are grounds for believing that his medical examination would afford some evidence as to commission of such offence. This is the purpose. But police officer has to make request to such medical practitioner for making such medical examination. But the police officer who is making such request must not be below in rank to the rank of sub-inspector. Means at least the officer of the rank of sub-inspector and above has to make such request to the medical practitioner. If such arrested person attempt to resist such medical examination, then police has power to apply necessary force on him for causing such medical examination. If such person arrested is female, then such medical examination must be carried on by female medical practitioner. What are the things which generally includes in such medical examination? It includes the examination of blood of that person arrested, blood stains on his body or on his clothes, then semen, then sweat, then hair samples, nail clippings, etc. And such examination can now also be conducted by using modern scientific technique, including the DNA profiling and other tests as such medical practitioner thinks necessary in that case. So the purpose of such medical examination to see whether there is any evidence after the evidence upon the body of that person arrested regarding commission of any offence by him. Then the next section in this line, that is section 53A, it is a specific section. Medical examination of a person who is accused of rape. So when any person is arrested on accusation of committing the offence of rape or attempts to commit rape, and when there are grounds for believing that an examination of his person, that is body, will afford some evidence as to commission of such offence, then he can be physically examined. Such physical examination, that is medical examination, must have to be made by registered medical practitioner, doctor. And then that medical practitioner, that is doctor, has to make a report of it after making such examination. He has to make it without delay. Doctor has to prepare without delay a report of such medical examination. And what are the particulars which should be there in such a report? That name of that accused person, address of that accused person, then the name of that police officer by whom he was brought for such medical examination, age of the accused, then marks of injuries on the body of such accused person, then the description of material taken, that is sample from the persons of body of the accused for DNA profiling, For example, blood sample, then hair sample, then if in that report that medical practitioner is mentioning his conclusion, then what are the reasons for coming to such conclusions? That should also be mentioned in that report. Then at what time medical examination is commenced and what time it is completed, it is to be mentioned in the report. And then such report must be forwarded to the investigating police officer immediately, and that investigating police officer has to forward it to the judicial magistrate along with the charge sheet. So we stop here, but we will discuss this topic further in our next video part.